for sentencing. I have had an opportunity to review the pre-sentence report. With respect to the pre-sentence report, are there any additions, deletions, or corrections on behalf of the people?
Judge, the people had an opportunity to review the pre-sentence report. I don't see any additions, deletions, or corrections on our.
What about that for page 1? There was no plea agreement?
There was, Judge. I was going to wait to address that at sentencing, but there was a plea agreement, Your Honor. I don't believe, and that's on my mistake, that the people gave a written plea agreement for the court file, so I don't think there was one in the court file.
Okay. So what was the plea agreement?
So the plea agreement, Your Honor, was for the original charge, assault and battery, to be reduced to a disorderly person. The people did have an opportunity to speak with the complaining witness, and that is how we came up with this particular resolution. There was a recommendation from the people for 12 weeks of anger management, no contact with the complaining witness, Ms. Alyssa McLaughlin, and the people had no objection to a delayed sentence.
All right, anything else?
No, Your Honor, that's all for the people.
All right, with respect to additions, deletions, or corrections, are there any on behalf of the defense?
Your Honor, I just wanted to indicate the same thing that Ms. Ritter did, that this was, we asked for this to be considered under 771.1, that if successful completion, this be dismissed at the end of the term of probation. I did want to address within the PSI.
Say that again.
Within the PSI, I believe as part of clarification or addition, if you will, I know it notes on page 7 that she's in a sorority with this individual, which I believe kind of makes it sound like she is having contact with her. Ms. Hsu is graduated. She didn't have anything to do with the sorority since her sophomore year. And I just wanted that to be clear, because when I read that, it sounded like these are people that were going to be interacting and having contact with each other through this sorority. And that hasn't been the case for over 5 years. So I don't know if there could be a notation that Ms. Hsu has not been involved in the sorority for over 5 years, just so that's clear that they're not going to be having contact with each other.
I didn't get that when I read it, but okay.
And Your Honor, I did want to address the dilute test as well as some of the terms and conditions at the appropriate time.
Ms. Ritter, anything from the people with respect to sentencing?
Your Honor, with respect to sentencing, I see that there was a recommendation from probation for 9 months. I'm actually going to ask the court, due to the original nature of the charge, that be amended to 12 months probation, with the understanding that Ms. Hsu is eligible for early discharge at the 6 months. On page 4, under victim statement, it looks like probation tried to reach out to the complaining witness and was unsuccessful. The people have been in constant contact with the complaining witness. Prior to today's sentencing day, she had all the information to appear at sentencing, and she also received information regarding restitution. I do understand that she has some co-pays with some medical bills that she was supposed to submit to the people. However, we did not receive that. So the people are, I guess at this point, satisfied if the court sets restitution at 0, because we have not received any information for the restitution. But other than that, Your Honor, the people have nothing further as far as sentencing.
All right, with respect to sentencing, on behalf of Ms. Hsu.
Thank you, Your Honor. I did want to address the dilute test. Ms. Hsu does not have an issue with drugs or alcohol. I would ask if the court is going to require testing, that she be allowed to attest immediately. That will be negative, and that the court not order any continued drug screening. I know that Ms. Hsu has been extremely nervous throughout this entire process. I know she was very nervous before this, and I think this is a situation where she overdid it with water. I would also, understanding what Ms. Ritter asked, I would ask that the court consider that this offense occurred over 2 years ago, that she was arraigned in June of last year, that she's had no issues with the court or with the complainant during that entire time, and that she works over 40 hours a week. She works from 8 to 6, 5 days a week, and perhaps the court would consider a shorter term of probation and or decreasing the community service. regardless of what is ordered, whether it's anger management or a drug test, whether or not that could be done in Troy where Miss Shu lives, and or if she could report via Zoom and or telephone if the court would allow. I know that I've had over the course of the last 2 years, she retained us when this incident occurred. I've had the opportunity to meet Miss Shu, to discuss this case with her at length. She is a very smart, articulate woman. This is completely out of character for her. She has shown the utmost regret and remorse over this incident, and she's going to do everything to prove this to the court, that she's going to move on with her life and you're never going to see her again. Respectfully, I would ask that the court grant leniency and consider our request for modifications to the recommendation. Specifically that she not have continued drug testing, that she be allowed to show through one test that she doesn't have any issue with drugs or alcohol. And I know she would like to address the court as well.
All right, Ms. Shu.
Sorry. I just want to start off by saying that I'm really sorry. This has just been weighing very heavily on me for 2 years now. I'm very ashamed, I'm embarrassed, and it's not an accurate representation of myself and my character. I've never been in trouble before. I'm not going to be in trouble after this. And I know that you'll never have to see me again. And I regret the actions that I made. And I'm looking to move forward from this. And I am prepared to do whatever the court asks of me as well.
Okay. All right, as I indicated, the court has had an opportunity to review the pre-sentence report. I am ready to impose sentence. Now I'm going to read something before I impose sentence. And anyone who has practiced in front of me for any even short amount of time, and especially people who know me personally, and everyone knows that I believe in chances. I believe in not just a second chance. I believe in a lot of chances. I believe that people have to be given grace to sort of make mistakes. People have to be given grace to get it right. There's no, when we're born, we don't get a book that tells us this is what you're supposed to do to live. And then some things are mistakes and some things are horrible choices that we make. And even in making horrible choices, sometimes we make horrible choices. Even in making those horrible choices, there's still room for grace. But I want to read something, then I'm going to impose my sentence. So when I was reading, and I'm also going to say this, of course, I don't know Ms. Shu personally. And so when I'm reading, or when I'm trying to know who you are, I'm just reading your resume of sorts, right? It's a resume. People's life become their resume. And your contriteness is noted. Your remorse is noted. But I'm going to read something, then I'm going to do the sentencing. And I'm reading on page 4. And I'm reading the police description of the offense. And I'm reading beginning at the sentence, starting with a struggle ensued. So it says a struggle ensued, and the defendant Shu grabbed the complainant McLaughlin by her hair and slammed her head into the concrete floor. Bar security broke up the fight and escorted both outside. The complainant sought medical attention for a concussion. And then on the next page, it says the witness Eads observed defendant Shu slamming complainant McLaughlin's head into the floor. Witness McGlitch observed defendant Shu pouring of beer over complainant McLaughlin's head, then assaulting her. So I'm sure we all can agree that wasn't a mistake. That was a horrible choice. And then, one can say that an individual doesn't engage in drugs or alcohol, but being an individual who tries on a regular basis to meet my daily water intake goal, I know that if I meet my daily water intake goal and I go take a drug test, my urine is not going to be diluted, too diluted to engage in a urine test. You have to drink an awful lot of water to dilute your urine. And when an individual's urine is diluted, it is generally, usually, most often, an intentional act. We don't slip up on diluting our urine. It's not an accidental dilution of the urine. And I've never heard, I think this might be the first occasion that I've heard of nervous drinking water. I'm nervous, so I'm drinking water. That's about the first time I've heard that in my 57 years of living. In my 17 years on the bench, I never heard anybody get nervous and they say, I'm gonna drink water. But it could happen. So all I know is that a urine test was ordered and then the urine test came back diluted. In my mind and in my eyes, a diluted test is a positive test. Every single solitary time. Every time your urine is diluted, I assume that you're gonna test positive for marijuana, alcohol, cocaine, heroin, and everything that's possible. Okay. So having said that, I don't know if the victim, because now we're post-conviction, but I don't know if the victim decided that they didn't want to, they didn't care about whatever the medical expenses were. Maybe perhaps, they decided to move on. Ms. McLaughlin decided to move on. Maybe her insurance covered the whole thing. But what I read in the precinct's report is an atrocity. That's just a shame. That's like one of those situations where people try to go back and get you back. You slam my head into the concrete, you pour beer on me. That's one of those things that if I, the person, the victim, if I'm not the type of person that is either forgiving or understands you shouldn't take the law into your own hand, that's the kind of situation where you try to get the person back. That was some horrible things that you did. And I appreciate the fact that you're sorry for that. But what your resume says is that you're capable, right? Sometimes when you go to a job interview, you try to convince a person, I'm capable, I can do that. I'm capable of managing a 50-person team. And the reason that I'm capable is because look at what I've done before. When a person is faced with a situation and they make a decision about that, that speaks to that particular person's character as to how they handle that particular situation. If somebody come and slap me in the face, it's gonna speak to the type of person I am if I haul right back off and slap them back, or if I try to say, oh, okay, let me find out why they slapped me in the face. You made a horrible decision on that day, and I don't know what the argument was or what the situation was, but it says a lot about your capabilities. All right. So having said,
Your Honor, may I address one thing? I'm sorry.
no, ma'am.
Thank you.
Having said that, the court is going to impose the following sentence. I am going to accept the people's request and increase the probationary period from 9 months to 12 months with the understanding that Ms. Shu has an opportunity for early discharge after 6 months. The court will set a final review date of February 24th, 2025 at 10 o'clock a.m. if we get to that point. But the midway review will be August 22nd, 2024 at 1:30 p.m. with the following terms and conditions. Ma'am, you shall not violate any criminal law of any governmental unit. That means no new cases. You must not leave the state of Michigan without consent of this court. You must make a truthful report to probation on a monthly basis, and you must notify probation immediately of any change of your address, phone number, or employment status. You will pay the following: fines, costs, and fees. You will pay $210 mandatory costs. You will pay a $500 fine. Court sets restitution at 0, having received no response from the victim. You will pay $420 supervision fees. That is at a rate of $35 per month. If you are discharged early from probation, that particular condition will be prorated. The court imposes a $50 pre-sentence investigation fee. You will submit to random urinalysis once a month for the first 3 months. The court will impose $30 for urine test. However, you may test at a location more convenient to your home. The $30 is only for testing at 36th District Court. If you test at a location more convenient to your home, the $30 is removed, but you have to pay that agency directly, regardless of their fee. That's not my issue. We charge $10 here at the court. If you need something more convenient to go somewhere else, you have to pay their fee, whatever their fee is. But you have to test. The test is random. The test is random. The nature of the test is random. Therefore, if they tell you to go on Monday and you show up on Tuesday, don't do it. Don't waste your money. You've already missed the test. The nature of the test is random. I will only be interested in the results from the day that the random test is pulled. So if they pull your name, if they pull your color, if they pull your number, and that says come on Tuesday, and you go on Thursday, I don't want the test from Thursday. Any diluted test is a positive test. It is a positive test. Any diluted test is a positive test. I am only ordering urinalysis for the first 3 months. If there are no positive tests in the first 3 months, then probation will discontinue the testing. The total fines, costs, and fees are, let me see. I believe it's $1,210, but let me see if that's right. Yes, $1,210. In order to be discharged early, you have to have paid $1,000 because the court will back out the supervision fee. So in order to get discharged at the 6-month mark, you have to have paid $1,000 of the $1,210. Additionally, you shall not use or possess any illegal substance. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not drive without a valid driver's license. You shall attend 12 weeks of anger management. You shall attend the Choices program through eBay. There was a recommendation for 5 days of community service, but I'm ordering Choices instead. I'm not gonna order the 5 days of community service. You should have no contact with the complaining witness. And there was also a recommendation not to consume alcohol. I'm not going to, honor that. Additionally, I will, despite the fact that I don't know why this deviation was given. Let me be clear that I disagree with the deviation that was given. It appears to me that the original charge was aggravated assault, and then it should have been perhaps deviated down or reduced down to assault and battery. Let me just say, I'm not the prosecutor's office. She has a right to charge whatever she want to charge. That's her business. It's not mine. I'm just noting for the record, I disagree with the deviation. All right, we are going to mail a copy of this order to the Seminole Street address or the Seminole Drive address, and then probation will contact you at the phone number ending in 4866. Is there anything else for the record on behalf of the people?
Not from the people, Judge. Thank you.
On behalf of the defense?
Yes, Your Honor. Is the court allowing this under 771.1?
I apologize. Thank you, counsel. Yes, I will. That's what I was getting ready to say when I went on a tangent about I didn't agree with the deviation. I was going to say, despite me not agreeing with the deviation, I am going to sentence Ms. Shue pursuant to 771. Therefore, Ms. Shue, if you complete the terms and conditions of the probation, even if you get discharged at the 6-month mark, then the matter will be dismissed. It will be removed from your record and the conviction will no longer stand. Anything further?
No, Your Honor. Thank you.
All right, then we're all set. Have a great day. Stay safe.
Thank you.
Thank you.
You're welcome.